Welcome to the ECLC presentation of Your Rights as an Employee. The information that we present during this section may have limited application to your particular situation. As a lawyer, I can provide legal information that may give you a greater understanding of how the law will apply to your situation, but I cannot give individual legal advice. For that, you will need to consult a lawyer of your own. The topics that we're going to cover in today's presentation are which laws apply to your employment situation, how those laws are applied federally and provincially, how a contract of employment is formed, some aspects of human rights and occupational health and safety, and some aspects of what you can do in the event you have an issue with your employer. The first topic today will be which law applies to your situation. There are two sets of employment laws in Canada, federal laws and provincial laws. If you are a federally regulated employee, usually you can tell because your employer will have undertakings that they engage in that cross provincial boundaries. This would include things like banking, international trucking, pipelines, telecommunications. If you are a federally regulated employee, the laws that apply to your situation are the Canada Labour Code and the Canada Human Rights Act. There are some important differences between federal and provincial laws. For example, federal employees with more than 12 months of service cannot be terminated unless the employer gives reasons showing cause for dismissal. This was a recent development in the law and highlights why it's important to know the difference between a federal and a provincially regulated employer. Another example of federal employers may be those who are appointed under a public statute. Many public servants, for example, are appointed by the Federal Canada under statute or legislation. That legislation governs the terms of employment of those employees, and you would want to know those pieces of legislation as well. Most employees in Alberta are governed by provincial law. There are four key pieces of legislation and law that govern employees in Alberta. There is the Employment Standards Code, the Alberta Human Rights Act, the Occupational Health and Safety Act, and the Workers' Compensation Act. This presentation will cover those in greater detail. In order to understand the nature of employment and how the laws apply, you do need to understand the nature of an employment contract. An employment contract is any agreement that tells you what the employer expects of you and what you are entitled to in return. Usually, the employment agreement will cover such things as your rate of pay, your hours of work, days off, vacation, benefits, and maybe some other things. Not all employment contracts cover all of those specific items. If you do not have a written contract of employment, you still have a contract of employment. Any contract may be made verbally or in writing. The writing is evidence of the contract. However, there are many things that employers and employees agree about that do not get reduced to writing. What the employer tells you about what you'll be doing for the job verbally may be part of the contract. They may have promised to pay you in a certain way or at a certain time. They may have told you certain things about the job. And if you've agreed to do the job under those conditions, then those things also become part of your contract of employment. If there is nothing in the contract, either in writing or verbally, about certain things, for example, vacation, there are still minimum legal standards that are set out in the Employment Standards Code. The Employment Standards Code sets out the minimum standards that all employers in Alberta must comply with. The first distinction to know between contracts of employment is whether it is a fixed term or an indefinite contract of employment. Some contracts are for a fixed term. Those contracts will expire on their own at their end naturally. Different rights are available to employees who have a fixed term contract as compared to an indefinite contract. An indefinite or an at-will contract is intended to last essentially forever until the employee is terminated or quits, or the employment can no longer be carried out for whatever reason. If you have an issue with what your employer does or does not agree to in the employment contract and you feel that your employer has breached that agreement, you can sue the employer for breach of contract. You can make a complaint to employment standards if those minimum protections have not been followed. You can have a human rights complaint, where you can contact the Human Rights Commission if you were treated differently because of ethnic origin or any other protected ground that is against human rights law to break. The essential point to understand is that no employment contract can break the law. This also applies to employer policies. Employer policies are parts of the agreement between the employer and the employee that may not be set out in the specific employment contract or discussed in advance. Many employers have policy documents that you are intended to review and understand later on. It's important that you review and understand policies, but you need to understand as well that those policies, just like any other written document or verbal promise from the employer, cannot break the law. The most important piece of law to know as an employee would be the Employment Standards Code. All employers in Alberta must follow the Employment Standards Code. However, there are some exemptions set out in the regulations. Certain types of work and certain industries may be exempt from some of these rules. The most useful resource to you, if you want to check whether an employer is following the employment standards law, is to check with the Employment Standards Office, a government agency. The officer can investigate and try to tell you whether the legislation is being complied with or not, and provide suggestions to you for how the matter can be resolved. In the event the Employment Standards Office discovers that there is a breach of the employment standards law, they can also make orders that direct the employer to comply with that law. As I mentioned, some employees are not covered by the protections in the Employment Standards Act, or certain of those protections do not apply to all industries and all employees. Most of the provisions relating to overtime, hours of work, vacation or holiday pay don't apply to agricultural workers, for example. Overtime provisions don't apply to management or supervisory employees. Overtime provisions also don't apply to domestic workers or domestic live-in workers, except during the rest periods and the days of rest portions. One note about management and supervisory employees. It is a common issue in Alberta that a person may be classified as a manager or a supervisory employee by the employer for the purpose of avoiding paying overtime or keeping certain records. However, the law is that in order to be a true manager or supervisory employee, the employee must spend more than 50% of their time doing management or supervisory tasks. If you have an issue with being classified or called a manager when you don't think you are in fact a manager or a supervisor, you may be able to seek a ruling from the employment standards officers. There are some other minimum rules that we'll cover. Pay is one minimum rule. Everybody knows that there is a minimum wage in Alberta. What some people don't know is that those minimum wages may be different depending upon the type of work that you engage in, and we'll discuss that later. There are some minimum rules as well regarding hours of work and overtime. This is also an area of generally poor compliance in Alberta, and it is misunderstood sometimes. The minimum rules relating to overtime is that all overtime pay must be paid at 1.5 times, 1.5 times your rate of regular pay. Overtime must always be paid for any time worked beyond 8 hours in one day or greater than 44 hours in 1 week, whichever of those is greater. So, for example, you may work 7 hours a day, 6 days a week, and you may not be entitled to overtime. But if you work that next day in the week and you go over 44 hours that week, you would receive overtime, notwithstanding that you never worked more than 8 hours in one day during that week. Alternatively, you may only work 3 days that week, but if each of your shifts is 12 hours long, then you would be entitled to overtime for 4 hours on each of the days of overtime. There can be agreements made between employers and employees regarding overtime. However, the rules are strict. Overtime agreements must be in writing, and they may only provide for one thing, that the employee may take time off within 3 months of the overtime worked. That time off must actually be taken. They can take the time off in lieu of the extra pay that they would be paid for overtime. If you quit before the time off is taken, or if your employment is terminated for any reason, then the overtime pay must in fact be paid out. There are also minimum rules related to holidays. Holidays, or general holidays, or statutory holidays, are days that the government has declared must be holidays for everyone. Examples are Canada Day and New Year's Day. You are entitled as an employee to receive the day off with pay. There are some rules relating to whether you're eligible. You must be available to work the day before and the day after the holiday. So if you take a vacation that has the holiday in the middle of it, you may not be entitled to get that holiday day off with pay. If you work on the holiday, all of your hours of work that day must be paid at 1.5 times your regular pay. If you work overtime on a holiday, then the overtime must be paid at 1.5 times 1.5 times the regular pay. So it does stack. There are some minimum rules as well regarding vacation. You do have the right to an annual vacation, but it is poorly understood the way that is to be taken under the law. After you have finished one consecutive year of employment with the same employer, you can become entitled to an annual vacation of 2 weeks per year. After you have completed 5 years of employment with that employer, you will be entitled to 3 weeks per year. That minimum standard only applies to taking one solid, unbroken period of vacation, which of course most people don't do. Also, many employers do allow their employees to take vacation before they've completed one full year of employment. That vacation must be paid, and there are rules governing when the vacation pay must be paid out. If you make an arrangement with your employer to take vacation in smaller chunks, or at different times and during the year, or before you've completed a year of employment, that's okay. Remember, these are minimum standards, not what you must do. However, in the event of a dispute with an employer, if you have an issue where the employer doesn't want to give you vacation, but you have earned it, you can find recourse within the legislation and from the employment standards officers to ensure that you do get that vacation. Maternity leave is also a difficult concept in Alberta. An employee is only entitled to maternity leave once you have worked for the employer for 12 consecutive months. These rules as well apply to paternity leave, any sort of parental leave. An employer can't fire you, lay you off, or change your position while you are on maternity leave. If you are entitled and you take the maternity leave, you must be returned to work in exactly the same or similar kind of a position. That means that it must be paid at the same rate, entail similar duties, and have similar levels of seniority and respect within the organization. Now, termination is always an issue and something that I hear about a lot in my practice. The general rule is that any employer can terminate any employee without any notice whatsoever if there's a serious cause, a just cause. Just cause is something that is difficult to establish for an employer. It has to be in the event of a very serious issue, such as stealing, dishonesty, or complete dereliction of duties. An employer who terminates an employee for cause generally needs to make out a very good case that the cause is justified. Otherwise, the employer will need to pay some severance. What most people consider severance or a package is actually pay in lieu of a period of notice. If not terminated for cause, an employee can still be terminated anytime and for any reason, so long as the employer gives the appropriate amount of notice. So the employee becomes entitled to a certain period of notice, or may be paid out that period of notice, or any combination of that. For example, if an employee is entitled to 3 months of notice of termination, they may be given 1 month notice, plus be paid out for the remaining 2 months. The rules might be different for federal employees. For example, a senior employee at a federally regulated employer may be entitled to different rights regarding termination than a provincially regulated employee of a similar duration. There are some minimum rules set out about termination within the legislation. Now, it is important to understand these minimum rules are set out under the Employment Standards Code. They cannot be modified, even if the employment contract says that they are different. Any law or agreement or anything that the employer attempts to do that does not comply with the Employment Standards Code is void. However, the entitlements in the Employment Standards Code generally are a lot less than what an employee would be entitled to at the common law, or what the courts say that that employee would be entitled to. The Employment Standards Code basically says you get 1 week of notice if you have been with the employer for more than 3 months, but less than 2 years. You get 2 weeks of notice if you've been there for 2 years or more, but less than 4 years. 4 weeks of notice if you've been there for 4 years or more, but less than 6 years, and so on. The largest amount of notice that is available to an employee under the Employment Standards Code is 8 weeks. That is very much less than what the common law typically allows. Generally, much more notice, usually double, triple, or sometimes quadruple the amount, is owed to an employee under the common law, unless the contract of employment says otherwise. You cannot contract around the minimum standards within the legislation, but you can agree with the employer that you will be entitled to less notice than the common law would otherwise say. That's why it's very important to read your employment contracts and to discuss them with your employer carefully, because you may be giving up significant rights if you have a contract that says, for example, you will only be entitled to the amount of notice provided by the Employment Standards Code. There are some minimum rules as well, as I mentioned, about minimum wages. In October 2015, the minimum wage in Alberta was raised to $11.20 an hour. It apparently is raising even higher than that. There is a different minimum wage that applies for jobs that include liquor service. The concept is that tips associated with the work will supplement the employee's income. This is important to understand because when a termination occurs of a person whose job includes liquor service, there may be an issue with the employer paying less than what would otherwise have been the minimum wage because of the liquor service included. It is important to account for those tips, though, during the termination window, and an employee who's terminated whose job does include liquor service may therefore be entitled to a further amount based on the amount of tips received. There's also a weekly minimum wage for many salespersons and commissioned salespersons. This includes land agents, certain professionals. It's generally thought of that a commissioned salesperson will only earn commissions if they make sales, but in fact, they are guaranteed under the legislation a minimum weekly wage of $446 a week. There's also a minimum monthly wage for any domestic employee, again, regardless of hours worked. That minimum monthly wage is $2,127. So it's important if you're a salesperson who works on a commission or a domestic employee to be aware that there are minimum wage requirements that may differ from that of an ordinary worker. Now, if the employer is breaking the rules, you may be entitled to sue the employer or to take legal action against the employer. A private lawsuit is not the only way to go. We will discuss the private lawsuits later on. But one of the most common pieces of law and legislation that it's important for employees to know when an issue arises at work is the Alberta Human Rights Act. The Alberta Human Rights Act and the Canada Human Rights Act are very similar. They prohibit discrimination in employment or any facet of private or public action based on protected grounds. Those protected grounds include race, color, ancestry, place of origin, religious beliefs, gender or age, physical or mental disability, marital status, source of income, or sexual orientation. Many things are covered under the Human Rights Act. Employees always have the right to work in a respectful, inclusive work environment free from discrimination and to be accommodated based on their needs related to the protected grounds. If an employer fails to do that, an employee may make a complaint to the Alberta Human Rights Commission. The Human Rights Commission is an entity which is governing all aspects of the Human Rights Act. They interpret, apply, and enforce the human rights legislation. The tribunals generated under the Human Rights Act at the Human Rights Commission have broad powers, broader even than those of the courts. If you feel you've been subjected to discrimination on a protected ground, it is always worth a call to the Human Rights Commission to check whether or not they believe that there is some form of discrimination. And if so, you may wish to make a complaint. When you make a complaint against an employer under the Human Rights Act, you should also know that there's a protection against retaliation. So even if the employer is found not to have breached the act, the employer may not retaliate against that employee, or they can be subject to stiff penalties under the Human Rights Act. Now, I mentioned accommodation. Accommodation means making changes to certain rules or policies within the workplace that ensure that those rules or policies don't have a negative effect on a person based on a protected ground. One of the most obvious accommodation issues is disability. If a particular worker needs a type of accommodation related to the setup of their workplace or the way in which the workplace operates because they can't get around or they have a particular disability, the employer must accommodate that. The employer must accommodate that to the point of what is called undue hardship. Undue hardship means an onerous condition for an employer, such as intolerable financial costs or a serious disruption to their business. The concept of undue hardship was originally conceived by the Supreme Court of Canada in a case involving a firefighter in British Columbia, Tawny Mayorin. Ms. Mayorin was a firefighter who was part of a fire hall which didn't particularly want her around anymore. The fire hall generated a series of physical standards that it was impossible for a female to accomplish, such as upper body lifting strength. Ms. Mayorin brought an action citing human rights legislation, and the Supreme Court found that that was not an appropriate action by the employer. Undue hardship in that case was found to be something that would completely disrupt the employer's business or the employer's ability to perform the firefighting duties. And it was found that the standards placed on her weren't related closely enough to the minimum standards required to be a firefighter. So you can imagine if a firefighter needs to be accommodated to the point of undue hardship, and undue hardship may include the physical standards required to rescue a person from a fire, certainly things such as the added cost for a better desk setup or some kind of a change to the business hours of a call center would not qualify as undue hardship. Next, we'll deal with unions. Unions are a slightly different animal. If you are working for a union, the union gets the legal right and the duty to represent you in all work-related issues and in negotiating with the employer. The important thing to remember is, as a unionized employee, you have no individual bargaining rights. All of your bargaining rights are given to the union to negotiate collectively. Unions then negotiate a collective agreement with the employer. That collective agreement becomes your contract of employment. Surprisingly, many union employees haven't even got a copy of their collective agreement, nor do they read it. It's very important that you do, because that is your contract of employment. The collective agreement may change many things. It can change your rights to sue an employer directly or to complain about them. It can change your rights to notice of termination, to work protections. It can change many of the laws and common law that would otherwise have applied to you. If you have a problem with your employer and you're a unionized employee, you need to contact your union right away. There is a collective agreement timeline in most collective agreements that provides for a very short amount of time, typically, to do anything about a problem. Sometimes that period of time is only days long. Grieving, or filing a grievance, is when the union officially complains about what the employer did. Unions do have a duty to help and advise you about your rights to file an agreement. However, they do not have to do so merely because you, the individual, want to. Remember, your rights are given to the union. If you're fired, the union might be able to help you get your job back or help you get a certain amount of termination pay. And some unions are very effective at doing so. However, if the union doesn't wish to do so or tells you that their legal counsel advises them not to, you may not have the ability to do anything else. Under the Alberta Labour Code, which is a different piece of legislation, every person has the right to join and participate in a union. There can be no retaliation or discrimination by an employer based on joining a union. That is called an unfair labor practice. Unfair labor practices in the application of the Alberta Labour Code are governed by the Alberta Labour Relations Board. If you have an issue with your union or with a unionized workplace, you can contact the Labour Relations Board for more information about your options. Unions do have a duty to represent you fairly, and if you do not feel you've been fairly represented, you can make a complaint to the Labour Relations Board. Unions also, like employers, can't discriminate against you or deny you membership due to a protected ground under the Human Rights Code of Alberta. The human rights legislation applies to every relationship and basically trumps every other arrangement. Next, we'll talk about workers' compensation. Almost all employees in Alberta are covered by workers' compensation. It's an insurance policy essentially for injuries or illness suffered at or because of work. It is generally mandatory for most workplaces to participate in the workers' compensation scheme. Some employers do attempt to get employees to give up their workers' compensation rights or discourage employees from making complaints because, like any compensation scheme that's based on insurance, the premium that the employer pays does depend on usage. However, it is very important that you never agree to give up your rights to workers' compensation and that you don't rely on your employer to make decisions for you related to workers' compensation. If you are injured as a result of work, which may be at the workplace or may not be at the workplace, you should always make a workers' compensation claim as soon as you possibly can. Don't allow your employer to suggest to you that you shouldn't if you feel that you should. You should take immediate positive steps on your own to obtain appropriate health care and get your healthcare practitioner to assist you in filling out the necessary forms to file a workers' compensation claim. Now, workers' compensation is governed by the Workers' Compensation Board. They make the decisions on whether or not to pay or continue workers' compensation payments. If you are refused compensation by the Workers' Compensation Board, there are appeal rights available, and you can contact the Office of the Appeals Advisor at the Workers' Compensation Board to help you file that type of an appeal. If you're a unionized employee, your union may also be able to help you with that. People don't understand that workers' compensation is a very important aspect of their job. If you suffer a catastrophic accident or illness, even if it is just related to your job but doesn't actually occur at the job site, you may have significant benefits that are available to you and your family. One example of how important workers' compensation benefits can be came in an actual case where an individual was killed in a car accident on his way to work. It didn't occur at the work site. However, his family was able to access the Workers' Compensation Board benefits in order to bring and pay for several legal actions against the person who caused the accident, as well as their insurance companies, which resulted in substantial coverage and support from the WCB to the worker's family. That didn't occur at the workplace, but because he was on his way to work, it happened as a result of the work, and that was covered. The WCB can make rulings on which aspects of matters or which injuries are or are not covered by the legislation. Occupational health and safety is a difficult area of law to practice because most employers in Alberta and most employees are unaware of all of their rights and duties under this legislation. However, it is extremely important. Generally speaking, any person has the right to refuse work that is dangerous and that they think will hurt them. No employer has the right to insist or force that an employee do dangerous work. The Occupational Health and Safety Code sets out minimum safety regulations. Unfortunately, most employers in Alberta are not perfectly compliant with occupational health and safety, and many are not even generally compliant with the most important parts of it. It is important to keep yourself safe and keep your workers safe in Alberta. The Occupational Health and Safety Office does have officers who can investigate, make rulings, and make orders, just like a judge in a court could make an order, for an employer to comply with occupational health and safety regulations. Safety regulations such as wearing a hard hat or safety boots are generally obvious, as are regulations regarding chemicals, how to handle them, how to identify them, and what the workers are entitled to know about them. Some are less obvious. We'll go through a few of the more poorly understood and regulated occupational health and safety rules. But again, if you have a question or an issue about the safety of your workplace, the best first place to go is to contact the Occupational Health and Safety Office. The obligation to protect workers is shared jointly between multiple parties. It is not just the direct employer who's responsible for it. Workers themselves are responsible to ensure that the workplace is safe, as are contractors, prime contractors, and even the owner of the workplace. Most employers do understand these regulations, but are not completely compliant, and many are very seriously non-compliant. Certain important guidelines are often missed. One of them is guidelines regarding working alone. Any employer who engages in potentially dangerous business must ensure that if an employee is working alone, they have a means of communication and a way of getting help in case of an accident at all times. This may be by two-way radio or by being within earshot of another employee. This may also include the requirement to have a policy setting out when a worker may work alone and where and who and how often they will be checked on. There are also guidelines related to first aid. It wouldn't surprise most people to learn that there are minimum requirements for first aid. However, most employers don't understand that those requirements are actually very clearly spelled out in the legislation regarding the number and type of first aid kits on site, as well as the number and degree of training of first aiders. For instance, in a large workplace, a very large and complex first aid kit must be made readily available, and a larger number of those kits with the growing size of the business. In addition, you may never perform work without a trained first aider on site, and the legislation explains how many must be on site and available to provide first aid at all times. There are also rules regarding securing equipment and any sort of equipment that could be dangerous to workers if it moves, shifts, or rolls. This can include the storage of materials, overhead storage in a warehouse, trucks that could roll on their wheels, or any sort of boom or arm that could swing around. Those must be secured and workers must be protected from their movement. There's also fall arrest, which basically means if an employee is going to work above a certain height, and it's actually not very high, by climbing a ladder or working on a platform, the employees must be secured to prevent them from falling. High ladders and lifting platforms must always have a security or a fall arrest system to prevent the employee from a catastrophic accident. Another poorly understood section of the occupational health and safety legislation is the need to perform hazard assessments. Many high-risk workplaces in Alberta have caught on to this and do what is called a morning meeting or a toolbox meeting before going out to work tasks every day. Hazard assessments in high-risk environments should be done daily, and the task is to write down and identify all of the work tasks and identify all hazards to workers and formulate multiple plans to eliminate those hazards. An employer who does not perform hazard assessments can be found significantly liable under the occupational health and safety legislation for any accident that does result. And the occupational health and safety officers can order those assessments to be done for the safety of workers. If none of the legislation or the offices in charge of enforcing the legislation can assist you with a matter, you may still be entitled to sue your employer in small claims court or at the Court of Queen's Bench. Before taking any sort of legal action, I would strongly recommend speaking to a lawyer, maybe at the ECLC or any other legal advice that you're able to obtain through a lawyer referral service or legal aid. You can bring and advance small claims in provincial court on your own, and the court is set up to deal with self-represented claimants. Those claims can be filed at the provincial court and served upon your employer. However, it is important to know what the law is regarding your claim and your entitlements under employment law. I highly recommend consulting a free legal reporting service, which you can access on the internet, such as CanLii, CANLII.org. In the event you need further legal advice about an employment-related matter, please come see us at the Edmonton Community Legal Centre, and a lawyer who volunteers at the centre can give you some information and assist you in drafting claims, bringing claims, and representing yourself. Thank you for watching. I hope you found this presentation useful. For further information, please do contact the Edmonton Community Legal Centre at the information on your screen.